afternoon. Go. Good afternoon, Mochineke. From wherever you are. Greetings from me, Barrister Jofo, the Council to IPOB. First of all, before we proceed to update Mochineke on the outcome of today's proceedings, it's pertinent and compelling on the part of Mochineke to also observe a 1-minute silence for the death of our elder statesman, Chief Chukwuemeka Ezefe, who we informed the court today that passed on yesterday. So let's observe 1-minute silence in his honor. May the soul of our daddy Chukwuemeka Ezefe. Today, as you are aware, we are very expectant of a positive outcome in court today, on Supreme Court. But we are not pleased. We are unhappy. As you are aware, no Biafrans are unhappy today. We are very unhappy and dissatisfied. The matter actually came up today for judgment, and I will give basic highlights in line with the court's assessment of facts and pronouncement. But the court didn't go into detail of judgment because of the time constraint. So when we get the judgment and look at it, we'll probably give further information to the public and Biafrans. First of all, the court, in discussing the merit of the case today, appeal before the court, said, observed and roundly condemned the invasion of Mazi Nnamdi Kanu's premises on the 14th of September 2017 by the agents of the state, Nigerian security agents. The court condemned the invasion of his premises on that day. The court rightly observed that then Mazi Nnamdi Kanu was facing trial before the Federal High Court and was granted bail. That if in the course of enjoying the bail granted him by the Federal High Court then, and committed any offense unto law or violated any of the terms of the bail condition, the federal government ought to have gone to the same court and applied for the bail granted him to be revoked on the ground that he violated the conditions attached to the bail. But in this case, they didn't do that. They went to his premises and killed. And in an attempt to kill him, they killed a lot of people and escaped. So the court condemned this very act. Secondly, the court condemned the act. The court also condemned the fact that the federal government went to the same court, same Federal High Court, seized of the matter, to apply for the bail granted Mazi Nnamdi Kanu to be revoked. The court condemned it. Court queried, why should the same federal government that sent his agents, security agents, to Mazi Nnamdi Kanu premises on 14th of September possibly to kill him? We also, because they failed to achieve their ulterior motive, go back to the same court to ask for the bail granted to be revoked. The court condemned it too. Thirdly, the court condemned the manner in which Mazi Nnamdi Kanu was abducted in Kenya, in clear violation of all international laws and territory. The court condemned it and cautioned on federal government to also guide its agencies on the manner in which they are using brutal force against civilians. So these were all roundly condemned. However, the court stated, or possibly likened this case to a situation whereby, in court's analogy, the courts draw analogy between this case, or the substance of the appeal, on a situation whereby the security agents were asked to, were on a search in a property, and possibly during the search, they were not armed with search warrants. But at the end of the search, they were able to come up with materials which are items which are very important to the case, or indictable items. So the court likened this case to a situation whereby the police went to conduct search and illegally, and possibly, or security agents went to conduct search and possibly got interested in indicting materials. In that case, it is immaterial that the manner in which the premises was searched was illegal, or that they were not armed with search warrant at the point they were conducting that search. But the fact that they got items that will be relevant to the proceedings of the court, that items will be utilized. That's what the analogy court draw between this case, unfortunately, between the case and the scenario I just painted. So the court said, though there was obvious illegality in the manner in which Mazi Nnamdi Kanu was kidnapped, the court used the word kidnap in Kenya, and consequently extraordinary addition to Nigeria, in gross violation of the pertinent international laws and treaties. But the fact that he's in Nigeria, that he is to be binded by Nigerian law. So according to the court, that that he cannot, is to be allowed to face the trial before the Nigerian law. That can no longer be allowed to go scot-free, as in to take advantage of the manner in which he was abducted in gross violation of his right. However, that we can maintain civil action against the authority, the state government, the federal government, on the manner in which his right was grossly violated, that it can give rise to civil action. That's what the court said in substance. And consequently ordered the matter to the trial to commence before the Federal High Court. So as you are aware, because it's important for me to explain, that before the Federal High Court was 15-count charge that was sometime before preferred against Mazi Nnamdi Kanu. And in view of the frivolous nature of the charge and the emptiness of the charge, an objection was raised by defense team led by Professor Michael Zekome to the competence of the charge, and 8 count out of 15-count charge was struck out by the Federal High Court. So remaining 7-count charge. So being dissatisfied with the remaining 7-count charge, an appeal was filed against that 7-count charge before the Court of Appeal. So
by the federal government,
by us, by we defense counsel led by Professor Michael Zekome. So, and on October 13th, 2022, the Federal High Court delivered a sound judgment. The Court of Appeal delivered a very landmark judgment, a unanimous judgment indeed, and consequently struck out the remaining 7-count charge in allowing our appeal, and further directed that Mazi Nnamdi Kanu will not be tried before any court in Nigeria again, or even detained further, and directed the federal government to release him unconditionally. So this were the judgment of the Court of Appeal delivered on the 13th of October 2022. Federal government being unsatisfied with that judgment, filed appeal before the Supreme Court, for Supreme Court to dismiss the judgment of the Court of Appeal. So that was the decision of the Supreme Court today. After this observation I earlier mentioned, the court proceeded to allow the appeal filed by the federal government and directed that trial should start. So we're going back to Federal High Court any month from now to start.
Is it for a normal trial or for trial awaiting trial?
I'm coming. I have 2 questions. Number 1 question is, to my understanding, I believe so much that the Supreme Court is the final stage, or the higher level of judiciary. So why referring them to Federal High Court, since the Supreme Court is the high authority? That's number 1.
This question has been asked by someone before now, and
okay,
and it's important for me to clarify before going to the second question.
Okay.
So I will take that question along with the one you asked about whether it's going for a waiting trial. Of course, you know that before now, what we have before the Federal High Court against Mazi Nnamdi Kanu is 7-count charge, because out of that 15 is the court struck out 8-count charge, remaining 7. So of course, we know that at the point an appeal was filed against that 7-count charge, to remaining 7-count charge before the Court of Appeal, that the matter was still live before the Federal High Court. So because it was adjourned then for report of proceedings before the Court of Appeal. So and on 13th of October, when the matter came up, when the judgment was delivered by Court of Appeal and consequently allowed our appeal, we eventually went back to Federal High Court to report the judgment of Court of Appeal. So on the day we went back to Federal High Court to report the judgment of Court of Appeal, the court was addressed on the outcome of the judgment before the Court of Appeal, and court consequently adjourned that matter sine die. So that means the court didn't give a date the matter will be coming up, because the court is waiting for the outcome of the judgment of the Supreme Court as the final court of the land. Because once the Supreme Court, even the Supreme Court that dismisses the appeal today, that will be the end of the case. So the fact the matter was at Johnson that shows that element of life on the 7 count trial before the Federal Court.
It's still there.
Which, yes, of course, which though has been struck out by the Court of Appeal, but still live because the appeal process stay on until when consummated. Like now it was consummated today. The appeal has been decided and they're allowed by the Supreme Court. So we are not going back now to activate that 7 count maiden charge, which was
on a normal trial now.
On the first normal trial. So which was before the trial, before the Federal Court. So because that matter now adjourned in this Senate indefinitely will now be caught up now. So it will need either the prompting or the prosecution, which ordinarily if you allow them now they will probably go to sleep. So we all are going to follow it up to ensure that letters by between now and Tuesday, a date is given for the matter to court.
For normal hearing.
Yeah, for normal hearing on the matter. Yeah.
Okay, number 2 question, which is my last question. Unlike before, Mazi do appear before the court, but today, why did Nnamdi Kanu not appear physically?
Thank you. You know what is before the Supreme Court is appeal against the judgment of Court of Appeal. It's only in limited circumstances that an appellant will allowed to appear in court himself. Though we made an attempt to ensure that he's in court to hear at least to practice to know what's being decided against before the Supreme Court, but it's an onerous procedure for him to be allowed to be present in court, particularly when the trial is not going on, because it's an appeal that's being had. Like now we're going back to the Federal High Court now. He must be present at any day the matter is coming up for
the trial.
He must not be absent. Any day is not in court, the matter will not go on. So he must be present on any day the matter is, because the matter is not coming up before the Federal Court for trial, full trial. Yeah. So he must be present on any day the matter is coming up before the Federal Court for hearing.
Okay.
So it's just appeal process from the Court of Appeal to Supreme Court that was concluded today. And during appeal, it's only on limited circumstances that the person will be allowed to be in court.
Okay, so I have another question I wish to ask. Did the court frown or smile at the refusal of discharge by other courts? I learned that some other court, or maybe the appeal court or one other court, discharged or granted something to Mazi Nnamdi Kanu, and it was not honored either by the DSS or by the powers of visible hands that we cannot see. Did the court actually celebrate this, or they frowned at it?
No. The point that we are talking about appeal process is this is a judgment that was granted by delivered by the Court of Appeal. We are discussing about the substance of the judgment. So, and these are far-reaching pronouncements by the Court of Appeal in that judgment. So, delivered, file an application for stay of execution.
Okay.
So, though as unprecedented as it is, the Court of Appeal started over by a different panel of Justice of the Court of Appeal, granted that application, and the judgment was stayed, and they relied on that order, staying that execution of the judgment of Court of Appeal, not to honor the order contained in the substantive judgment. So they rely on the order, staying the execution of that substantive judgment, not to honor it. That was what they did in substance. Because they tried, regardless of how illegal it is, they, of course, government, they rely on that unprecedented order, staying the execution of the substantive judgment of the Court of Appeal, not to honor that order, the terms of judgment of the substantive of the Court of Appeal. So before proceeding on appeal. So the decision of the Supreme Court today was on the merit of the appeal. Actually, my Lord Justice that delivered the judgment today before the Supreme Court didn't delve into the substantive argument, findings, and conclusions before the court. It just went into decision, the court decision of the Supreme Court, and possibly highlighted some highlights, as I pointed out, and before probably making progress as to the decision of the Supreme Court.
Okay, so the other message I have for you now is, the question I have for you now is, do you have any message for the common man from the Southeast? Because due to the situation in Southeast currently, I assume that everywhere is under panic. People are afraid, people are not comfortable, and if you look at it from the larger picture, you see that many of our people will not come home for Xmas due to fear or panic of one thing or the other. So is there any message you have, not directly from Mazi Nnamdi Kanu, but maybe from your own point of view? What advice or message do you have for our people, sir?
Okay, speaking as a lawyer, number one, I'm also as a lawyer to IPB Lead Counsel. I want to re-emphasize that no matter the efforts by anybody, regardless of their position, institution, to break down Biafrans, I would advise restraint at this point in time. I would advise utmost restraint. What I know for sure is that Mazi Nnamdi Kanu will be out. We have gone through the charge meticulously in between lines, even the one they amended and defied. So we've gone through them. And I know that they cannot effectively substantiate that charge during trial. And we also intend, because Nnamdi Kanu is medically unfit to face the trial as it stands today, because I'm the one that's been visiting him with doctors to at least to attend to his theoretical mental health condition. So first of all, he has to be attended to medical wise. And so in that case, we'll be talking about him being granted bail as soon as the case is called up, because he has to be sound health wise before he can face trial. Yeah. So once the charge is called up, any month from now, an application for bail should be also filed. Because we have his full medical records and recommendation by his medical doctors that require him to even attend to undergo advanced medical treatment outside this place. So these are compelling facts that are going to bring the attention of the court, because it's only a living person that can stand trial. So, and as it stands today, if based on documents available, medical documents available to him and also to the SSS, they have it, that he can be competent to stand trial, because he has to go and attend to medical situation. That's number one. So, and on that note, I would advise our people to apply greater restraint. This is what I can say as a lawyer. Okay, but I can't advise people to go into violence and protest. I won't say that. What I will say is restraint. Believing that the will of justice may be delayed, but in the end, there will be happiness. And we're not leaving anything on stone to ensure that it's given the best of representation. So at least he has a very erudite advocates in the matter. So thank you. That's all I can say for now.
Okay. I don't know if I should just throw one last something to you, because it is very, very important. When you are in a jungle where it is critically assumed as a palace, but you inside your heart, you know that this is a jungle, nothing better may come out of a jungle. This is just a parable. Now, picking some few points from this, my illustrations now, I want to bring it to reality. Do you think it is possible the same court, the same federal high court, would grant bail to...
No, let me just... I don't want you to print the outcome of the application. It's an application that will come live before the court. I wouldn't want to discuss that, because I know that when we get to the bridge, we cross it. And I know what to have before us, that I'm not privileged to. When it has to do with medical documents, so, and I may not be able to discuss the substance of it now.
Okay, sir. So, is anyone influencing the release of Mazi Nnamdi Kanu not to be possible from your own idea, or is there any information you've picked like that?
You know what I can talk here is law. As a lawyer, so I don't want to talk politics. So anything outside that. So okay. What I'm discussing with people is law. I don't want to go into political aspect.
Okay.
When you probably maybe some people can discuss the political aspect of the case, but I'm talking law.
Okay.
And anything about law. Thank
you
so much.
Thank you very much. Thank you very much, sir. We appreciate. Thank you.
What do you have to tell our people?
I will call everyone. I would ask everyone to stay calm. There is still hope and light at the end of the tunnel. That is the little I know I can say. And if you are one of those people who carries gun about in Southeast, maybe because you want to scare or chase people away, please be very, very careful. There is no need for that. Ibusi umunegi ginonye ebiechi. Oya wo ofihe nwere gwa gi. Ebe obu na ye torugo to that level, I need tears o Johnny mumunna anyi. Enwere zo ye kwa abia ụlọ. Onye ruo ezigbote ụlọ. ọbịa nwanne ya nyukwu ọ chọwa ka ya esi wee mee gbaa ya ọkụ wee tag ya na ọ bụ ndị unknown gun man. Ọ dịrọ mma n'ala Igbo. Ofu ụbọchị it will be a thing of disappointing at the end. Ọ bụ ma Mazi Nnamdi Kanu tacha afọ wee nata wee bụrụ na ndị ahụ ọ na-azọ ka ọ zọta ha ndụ ejigo aka ha wee mebisie onwe ha. Ekutere mmiri ka eji saa gị ahụ, ọ bụrụ na ijigo aka gị gamakpuo na pọtọpọtọ ọ ya adị mma. So the little message I have for ndị Igbo, onye ọbụla jisi ike nwee ndidi, ụzọ ọbụla ya esi wee nweta udo isi ya wee weta udo. Ogbugbu a na-ekwugodo okwu ya na southeast, it is the worst. Even from certain information, I believe that Obama Nnamdi Kanu n'ihe or yaha they happy. And another thing, the last thing I would say here is this. For example, Barrister Ifeanyi Ejiofor here, and with some people who keep on social media, all his relatives, and I wouldn't know. But today I am in his office. He welcomed us open hand, right? At the end of the day, simply because you think you love Mazi Nnamdi Kanu, you don't love Mazi Nnamdi Kanu more than the way Barrister Ifeanyi Ejiofor should love him. When you came in here, there was no 1 year ago, who are you? Or Chideka Asachi before get Batana office. But by the time we do certain things, it gets to that level. So we should be able to equally face whatever comes out of it. That's the little I know I have to say in addition.
Igbo. Maka ndị na-anọghị bekee